Our profession involves working with bad scenarios.
What interests our audience? We had a social package that did not belong to an Indonesian, for the contract was made. Here are the top 3 points that an investor should pay attention to.
Our client has the right not to pay, the right to take back their money. What about the transparency of the figures?
We'll keep some of our professional secrets to ourselves today. Hello everyone. Today I am paying a visit to our very important legal partners at Bali Business Consulting. And with Igor Zhuk, we will be learning many interesting, thorough and comprehensive aspects about an important legal review called due diligence. Our clients often ask why they should do due diligence, what it provides and what to pay attention to. It was requested by our audience that we decided to make this video. So the first question for those who are not familiar with the topic at all, could you please explain what due diligence is in general?
Yes, good afternoon, Alexander. Indeed, due diligence is a comprehensive review of a particular object. As part of our services, we talk about legal due diligence, which means that we thoroughly and comprehensively check each and every single legal aspect of the project, process, or company, no matter what. If we are specifically talking about and focusing on our company's highly specialized and detailed due diligence service for the purpose of developer verification and validation, it is quite a complex and intricate process divided into several distinct and important stages, at the end of which the client should receive a thorough and comprehensive legal assessment and evaluation of the developer. You will receive detailed recommendations for modifying and amending various contracts and project documents. Additionally, you will get some key bullet points that highlight the risks involved in this particular deal, ensuring you are fully informed and prepared to make the best decisions. For some clients, it can be helpful to simply read through the contract with a lawyer in greater detail to understand certain points and have them explained again and thoroughly. To explain it in simpler terms, so to speak, in other words, essentially, basically, you could say,
can we highlight the top 5 or top 10 key points that should be paid attention to? And when it comes to due diligence, specify what is checked, because it's a very broad term like checking the developer's documents. So what exactly is being checked? For example, the land lease agreement with the landlord. And just to clarify, what exactly is being checked?
Look, each of our due diligence processes is divided into 3 main sections. This includes the examination of land documents, company documents, and other relevant project documentation, specifically contracts, such as construction agreements. In the land section, let us refer to it as such, we first check the developer's legal capacity to enter into a deal. And what does legal capacity mean in simple terms in this context? I will explain right now. And we examine the details regarding the land plot itself in detail. As part of our legal capacity review, we examine the developer's documents regarding land ownership, whether it is freehold or leasehold. Of course, if we look at the market, the majority are leaseholds, which actually requires very thorough proofreading, extremely careful proofreading, very careful proofreading, because depending on the provisions of the developer's lease agreement, we can draw conclusions about the presence and extent of the risks that the client bears. So naturally, an ideal situation is when, of course, a developer or client comes to us with fully paid land, but unfortunately the market is currently developing a bit differently, and most developers, even large ones, are working with installment payments for land, where the sales phase begins before full payment is made. In this regard, we need to thoroughly review the lease agreement to understand the extent of risks in case of underpayment for the land, to assess the prospects of extending the lease of this land plot, and to generally understand how well the developer complies with this agreement and ultimately can transfer this right to the client. This pertains to the section on title documentation. As for the land plot, in terms of our current situation, it is indeed somewhat more complicated and complex. It should be divided into several elements as well. The first is also the verification of encumbrances. We check for encumbrances on the land plot. For this purpose, we obtain an extract from the BPN, Bureau of Public Notaries, and the Land Department, within which we can see if there are any blocks, liens, or other encumbrances on the plot. For instance, if the certificate is pledged in a bank, the land certificate, this will be highlighted in the extract. It also shows any outstanding tax liabilities.
Can you provide examples of conducting due diligence on a block of title documents and land documents? What cases had serious violations where you advised against investing to show real-life scenarios? This is theoretical, but what about in practice?
Well, let's do it this way. I'll give without names. Yes, of course, without any names. I'll first give a specific and detailed general case from practice. This is an example where the developer's contract payment is made in multiple installments over a specified period. For the land acquisition, the payment terms are structured to ensure timely and efficient transactions. Yes, regarding the land, it is explicitly and clearly stated by the developer, without any ambiguity, that the rights under this contract can only and exclusively be transferred once full and complete payment has been made within the next 3 years, as stipulated. At the same time, the developer wants to sign a leaseholder agreement, not even an investment agreement, which is of an investment nature, which more or less would still be acceptable essentially, but wants to sign a leasehold agreement that is not notarized in any case. With the investor, yes, with the investor, securing the investor by transferring the land to him, despite the fact that his contract directly blocks this action. That is, he receives the contract, but it will not have legal force. This is an example of a basic day-to-day situation. Our second example is the presence of debt on the land plot, specifically regarding the tax, such as property tax and other related matters. The project is already very nearly approaching completion, the construction will soon indeed be finished, and the leaseholds will be ready for transfer. The client approaches us to assist with the notarization of the deal. The developer accordingly says, yes, we are all ready, but in the statement we have a land plot blockage because we have tax arrears. And perhaps I'll tell you a funny story about this. This is a developer who has a lease agreement and is ready to make a deal with a client. The client comes in, and as part of their due diligence, they provide the previously conducted due diligence report. They also file a complaint to us, asking us not to take too long because they wonder why we need to check them for such a long time, considering they are already being checked thoroughly. It should be clearly and thoroughly explained that their lease agreement rights were actually a lease from a lease, meaning in fact a sublease. We start by thoroughly and meticulously reading through the entire lease agreement, and the lease agreement incorrectly states the land certificate number. Well, in the literal sense, the land certificate number for the construction site and the certificate number mentioned in the render contract differ by 1 digit.
Essence, they are on land with a contract that contains an error.
They have no rights to the land or anything at all. According to the contract, they have nothing to confirm it. Error. And the most interesting part is that the error was made when creating the original master list, then it was duplicated in their sublist, and then it was duplicated again in the sublists. So there was an error at the root, it just wasn't checked and noticed. Yes. And then we highlight this issue, everyone starts running around redoing their contracts and making amendments. Thank God all parties responded adequately to this issue, were able to quickly make amendments to the contract and promptly fix everything. But such a precedent did indeed exist.
It's just appropriate here. There could have been another situation where you would simply say, well,
yes, you just need to understand. For example, I don't know how interesting this experience is for our listeners, but if we have an Indonesian who has leased out land, it can happen that he has a lot of land in one place, and the certificates can really differ by 1 digit. He could have mixed them up and leased out the wrong one. In this case, he could take a stand and say, you're building on my land, I wanted to lease you another, that's your problem. But in that situation, we had a certificate which did not belong to the Indonesians who made the agreement based on it. Therefore, he was ready to cooperate in this and make prompt corrections.
Returning to the topic of due diligence, there are title documents and land documents. What else? Or here?
So we also check zoning regulations for the land in detail and thoroughly to ensure compliance. This is quite an important point, and indeed this is a crucial aspect in terms of fully comprehending what specific requirements we have outlined for the developer and what degree of flexibility they possess in securing a building permit. And this will be directly related to the next section, because depending on the information we obtain from studying zoning regulations, we will provide recommendations for making detailed amendments to the main contract with the client so that the client clearly understands what permits and documentation the project will require. Regarding the land plot, we thoroughly check in order to ensure that there is adequate and proper road access. Can we come over to your place? I mean, it's actually extremely, very important. It's such an extremely pressing issue that many of our plots are indeed quite expensive, and people are not particularly interested in buying near the road anymore. They start moving deeper where it's still cheaper, but there are no access rights. There are no access rights, and thank God, yes, some developers are dealing with this issue and resolving it. And someone, well, we have a gravel road, we don't know whose it is, but we use it, everyone uses it.
Understood. If we specifically consider the contract between a developer and an investor, this is what interests our audience the most. In other words, based on experience, what points should be highlighted and where is the developer willing to negotiate, for example, and where are they not? And from practice as well, what you most often revise, where to pay attention, where the catch is, all these points.
Yes, first of all, I will make a small disclaimer so as not to devalue my work and the work of my colleagues a bit. Today, we will keep some of our professional secrets to ourselves and will be happy to assist your clients not only through personal consultations, but also through other resources such as online support and detailed guides. Naturally, if we are talking about some basic points, we follow the next detailed and comprehensive list of guidelines. For example, this includes aspects that are crucial for understanding the topic. The subject of the contract is clearly and explicitly defined. We fully and completely understand what is being transferred under the contract, where it is located, and for how long it is being transferred in detail. The second very important point to consider is that we pay very close attention to the responsibility of the involved parties and how carefully proportional it is, because a common misstep of Balinese developers is slightly disproportionate penalties, which often happen due to failing to accurately gauge the severity of infractions. For instance, a minor mistake might receive an overly harsh penalty, causing confusion. That is, for the client, it can be approximately 1% of the missed payment obligation per month, while for the developer, it is 1% every 3 months. Therefore, the calculation of the payment is different, but the final figures are like this. We check proportionality accordingly. In addition, furthermore, we are also very deeply interested in the detailed mechanics of precisely implementing penalty sanctions. What needs to be said again here? Our profession involves working with bad and challenging scenarios in our field. If everything indeed turned out very well, we are extremely happy for our clients, but this is not the block we initially prepared for and absolutely aim to protect. Our goal is to ensure that both parties clearly understand how to act and what happens if things go wrong. Therefore, one of the important, crucial, and significant elements is the exit points, which are essential. At what point and under what conditions does our client have the right not to pay, the right to take back their money, to get their money back? From which stage do they start receiving their penalty rewards?
And usually these clauses are not present in the original version of the contract at all.
You know, I won't say this about all developers. Many have already adapted to, let's say, the realities, including our recommendations, and many have already included this in their contracts on a permanent basis. But the issue is more about quality than quantity. You need to see what exactly is included and how it will work in much more comprehensive detail. In addition to this, of course, we carefully pay attention to the legality of the contract itself and also ensure, that is, we look at the company's documents in detail, review its list of licenses thoroughly and meticulously, and examine the contract carefully and comprehensively. One common example of what we recommend correcting is when a developer creates a construction contract, which is a legally binding agreement between parties, including terms, conditions, and responsibilities. A direct construction contract specifically, without having a construction license, because it is important to understand that the average market situation is such. We have a developer who acts as a moderator of funds, finding the necessary licensed contracting organizations, but does not actually have a license himself. This is the norm. He acts as a contractor. When a developer signs a construction contract without having a construction license, we consider this a drawback because under Indonesian law, they initially did not have the right to do so.
So Let's highlight the top 3 aspects, the top 3 points that an investor should pay attention to. First, what is the subject of the contract? Yes, the object of the contract.
Object, subject, that is indeed the subject-object component, that's correct. Next, indeed, are the penalties and exit points, their proportionality as well. And this is the correct specification of the parties' responsibilities within this process in terms of the final result. What should be delivered to the client, in what volume, and within what time frame, and also deadlines, that is, well, let me give you an example from practice. The most common one in real-world scenarios, all developers already indicate that they are obligated to deliver the project with the necessary permits. They commit to obtaining them. Whether it's SLF or PBG, both should be included. Let's skip this moment for now. But no one writes what type. No one writes what type of SLF and PBJ at this point. And we have a huge difference. We have a big difference. Indeed, it's either residential or commercial type. The residential type, potentially, if our legislation becomes a bit stricter in the near future, will not be suitable for short-term rentals, potentially. Only commercial will be suitable. And yes, most of them end up making it commercial because they also take on the management and don't want to ruin their own reputation. But it's important to understand that if any of the developers hit a wall in obtaining commercial approval, they will switch to residential, which will make it significantly easier. According to the contract, he will say it's written, PBG is obtained, PBG is there. Sorry. Again, is this situation really common? As I said, no, it's not a very common situation. But our task is either to prevent their occurrence in the future or to make it clear to the client how to act in such a situation.
And this moment is what everyone is afraid of. Not afraid, but there is a concern that the developer may often delay the completion deadlines. So you also pay much attention to what will happen if standard sanctions are imposed and how to proceed.
Our task here is to make the calculation of standard penalties, the mechanism of their implementation, and the start date of their payment as clear as possible. Accordingly, appropriately, and clearly establish an exit point in case of a long-term delay.
Okay. The question is, when an investor signs an agreement with a developer regarding an investment contract where they acquire or invest in a certain unit, should they immediately sign a management agreement as well? This is a separate parallel contract. And here there are many nuances and questions, like if he can live there, handle the second part, the management contract.
In fact, we review it in detail and thoroughly explain it to the client, ensuring they fully comprehend every detail. This is because, in my professional opinion, my recommendation, which is extremely crucial and vital for all types of contracts, is to carefully read and review the contract first. This means that within the comprehensive and thorough scope of our legal reviews, we will ensure that your contract not only complies with all relevant laws and regulations, but also effectively addresses potential risks. Our detailed analysis will cover each aspect of the contract to provide you with complete peace of mind. But we often overlook certain aspects such as conditions. For example, the luxurious villa is priced at approximately $100,000. No one has sent us any offers at this very present moment in time. We do not currently know the price of this villa. We will not highlight the price in red for you because we assume that you will see the price and check it yourself. That's why I always tell the client before signing, is the price correct? We are not aware of your correspondence. Maybe you have already agreed with the client. Maybe you have agreed, maybe you were promised a discount, but it is not indicated here.
That is, they highlight such serious violations contradicting the norms of the law.
In general, generally speaking, go against the norms and carry potential risks for the client. However, the first stage of risk elimination is very important feedback from the client, because there are, in fact, numerous examples where clients actually came to us with quite unconventional comments that are easy to include, but we would never think of them ourselves.
In essence, we need to emphasize that this is a collaborative effort between the investor, the client, and the legal company.
And then it kind of makes sense. Then it makes sense because, for instance, the client has an extremely conservative Swiss bank, absolutely very conservative. They cannot make any payment without providing a complete and thorough set of necessary documents. This information is not available to me in any way. But when the client talks about it, when we discuss it with them, we understand that we need to change the payment date made by the client from 7 days from the date specified in the contract to 7 days from the date the developers provide all the necessary documents to the bank. And these are very different dates. And potentially, one small suggestion helped avoid a possible delay, dissatisfaction among parties, and so on. And we wouldn't have known about it except through direct and consistent and ongoing contact with clients.
In a private conversation, if we are talking about a contract with a management company, can you point out key points there?
Of course. In the contract with the management company, you need to pay attention to which set of responsibilities they are taking on, what liability they bear within this unit, and understand what financial burden will fall on the client. For instance, whether there will be separate payments for electricity, if these payments will be included in the management fees, or if they will simply be deducted and included in the overall expenses. Understand the actual level of client involvement required in the management procedure from the payment perspective. Clarify this matter. Next, we are particularly interested in the issue of taxes. Who exactly is responsible for paying taxes, for optimization and effective management? We are also interested in the reporting methodology from the developer. In what exact format is it provided, how frequently and specifically, and what are the consequences, if at all, of not providing it? Recently, I have become a big fan, as someone who really appreciates the description of bad scenarios. One developer approached the management contract very well. In my understanding, they approached the management contract very well. They detailed it thoroughly, explaining what happens in the event of a critical drop in purchasing power and occupancy, by providing detailed scenarios and potential outcomes, including various situations such as a significant economic downturn, in the case of a pandemic, and everything else. If for some reason or another our occupancy drops significantly and unexpectedly due to various external factors, they just described this mechanism in detail and thoroughly. So when the client first saw it, they noticed that the profit distribution had been slightly redistributed and everything else remained exactly the same. At first, the client was initially a bit wary, feeling that something was somewhat off. We had a conversation with him and agreed that in such a particular scenario, they wouldn't have the means to pay anyway, a bit more. Thanks to this inclusion in the contract, we at least theoretically understand what will happen and how we will act. Therefore, detailing is better than its absence. We are interested in the methodology to calculate the compensation agreement. In what form?
From what exact amount, in what form, and what about the transparency of the figures? Because it's also a frequent question. First of all, I was told about a case yesterday. I have a villa and the management company keeps telling me that there is no occupancy. And my friend comes over, looks, and there's always someone living there. What should I do? How can I resolve this situation? We might even come to you with this case. What should be done? How to manage cost transparency? They say $10K came in, 4 spent, 6 left. What were the 4 spent on? Why?
So what should be done here? First, detailing expenses, the developer's expenditures, providing receipts, invoices, and requiring some form of reporting. Can this be specified in the contract? This can be specified in the contract, but in this case, I assume it's a standard situation where everything is burned down, so let's fix it. That is, it is necessary to understand that the contract needs to be reviewed and amended before it is signed. Once the management agreement is officially signed, making any changes to it is a matter of voluntary agreement between the parties involved. If it is not signed, then our task is to detail the developer's reporting, including what is included. And what also makes sense to discuss are certain spending caps, certain threshold amounts, and the implications these have on the budget. It is crucial to consider how, because it is indeed important to understand that with the right amount of expenses you can sell anything. It could be unprofitable for one side, for investors. So I think when there is misunderstanding or dissatisfaction between the client and the management company and the contract is already signed, it is important to engage in dialogue, make adjustments. Once again, the issue of occupancy, as in your example, is a matter of how developers report in this particular context. I know developers who can give access to cameras. Don't believe it? Take a look. Complete transparency. Accordingly, those who have not yet signed the contract need to understand in great detail and thoroughly what the outcome of the contract will be and what all the responsibilities it entails.
Regarding the calculation, you mentioned the calculation method. Could you elaborate on the scenarios, negotiation, risk areas, and so on?
Yes, so you need to understand that earlier in the conversation, when you asked me what the developer is willing to agree to and what the developer is not willing to agree to in terms of contract changes, we approached this block regarding the developer's willingness to agree or disagree to various contract changes. We have the commercial terms of the developer. The terms are tied to their UBOFIN model, which they are not willing to modify under any circumstances. These include issues of commission, margin, and so on. Cost. Again, the cost, of course, when a large amount of capital is involved, you can ask for a discount, but that's not the point. If a developer has a specific method for calculating profit from management, and it has been in place for a long time, working the same way with all clients, having sold dozens of units, it is unlikely that they will change it specifically for you. But it's important to just look and understand what this number will be. And there are two calculation options. It's either a calculation based on revenue, income, or profit, meaning roughly 15 to 20%, or they get a share of the overall earnings of the villa, or from the profit that the villa ultimately generated. Well, I think we all understand which option seems more correct to me.
Yes. Question. I was asked a question during my presentation yesterday. What do you do if there is an initial version of the contract? The lawyers did the due diligence, worked on 15 points of amendments, and then the developer looked at it and said, I don't want to change anything. How do you handle such situations? Do you recommend not signing, or is your task to point out risks? The investor makes the decision. What is the situation here?
Look, we are very actively developing not only the service block where we simply provide a written opinion and then step away from the deal, but we also often take clients on for full transaction support. This option is more expensive due to the additional time we spend, the fact that we collaborate closely with the developer's legal team, and everything else. But the situation is straightforward. If the developer's position is, we won't change anything, then the client and I go back to the contract, list the risks, and identify where there are potential gaps here and there, and possible gaps in the contract. Let's weigh it for ourselves and really understand how genuinely interested we are in this project. If the client has carefully reviewed all the risks again, thoroughly and completely understood them, thought through how they will act in each case and agreed, then okay, good. It is very important to me that the client clearly comprehends their risks when entering a deal. I will absolutely not make the decision for them that they should not sign a contract with a bad developer.
Has there ever been a situation in practice where a developer was firm with arguments saying why they wouldn't do it? Has that happened? Or is the market such now that everyone is perhaps indeed prepared and willing to meet halfway and discuss at least some of the points?
I'll put it this way, in my opinion, the market is such at this very moment that there is always a point in discussing various certain aspects and perspectives, finding compromises between the developer's position and the client's position. It is always quite a large block of work that can be done and makes sense to conduct. The instances where we don't make any changes are very rare. More often than not, in the vast majority of cases, changes can be made. But there was such a precedent, and in fact, I can indeed even understand the developer to some extent. The developer had one discounted unit that they wanted to sell in order to successfully and efficiently sell. I think it was their last unit. They wanted to sell it. I think it was their last unit. It was their last unit, in my opinion. They wanted to close it to fulfill their commitments and so on, just to mark it as sold out. Interestingly, they actually provided him with a substantial discount, which was quite favorable from the perspective of our broker colleagues who were involved in the transaction. And the client came to buy, we started to assist, we checked everything, and provided a number of corrections. And the developer just said, listen, I gave a discount. I definitely want to sell it in this condition under the same contract that I sold it to everyone else. We won't be making any changes. Sorry about that. Is this more of an exception to the rule?
Yes. So this is an exception to the rule, but it did happen. Okay. If we summarize everything we talked about today, the key risks are, as I understand it, an incorrect land lease agreement, yes, and also the non-payment of some debt. Can you perhaps point out 1, 2, or maybe 3 key red flags, so people know to look there first?
First and foremost, we turn to professionals, such as lawyers or real estate agents. But if for some reason we review the contract ourselves, the first thing to check is the status of the land contract, including any clauses or stipulations, the status of payments, whether they are up to date or in arrears, and what happens if the payment is not made in full, including any penalties or legal actions that may be taken. The second is the detailed, thorough, and comprehensive description of various negative scenarios. Exit from the deal, penalties, and thirdly, responsibilities. What and in what amount you should receive as a result of this deal. It seems like such a trivial thing, but in reality, 2 out of 3 contracts lack the necessary detail regarding what and in what amount the client will receive in the end. There are also a number of more detailed points that I would be happy to discuss further.
I also want to emphasize that our audience should not place the entire responsibility for the contract solely on you. It is also necessary for the investor and the agency to be involved naturally, as well as from our side. Simply sending a file and asking you to review it and send it back for signing doesn't work that way. Because you don't know certain background details, what the developer agreed upon with the investor, and some arrangements, you don't understand which aspects need attention.
It's a team effort indeed. It's a team effort between the reviewing client, the client's representative, or the broker. It doesn't matter. But yes, it requires thorough and detailed involvement in various ways, because there are some aspects we have no way of knowing. And it is often easier to amend their contract, and it is very frustrating when this part was definitely and absolutely missed simply because no one conveyed this information to us.
Yes, I would even say that today we haven't looked at the worst cases, because I often talk about cases where there are indeed fraudsters who actually fake websites and pretend to be developers, which they are not, in fact. Therefore, I am truly very grateful for the incredible expertise and for what you have revealed today. Addressing the audience, I want to say that it's always better to double check, and when it comes to investments and the overall cost of these services, we as a real estate agency compensate our clients for the cost of this due diligence because we want to sleep peacefully, knowing that everything has been checked, that we are selling truly high quality real estate in a safe area with solid contracts. So friends, Bali Business Consulting is our key partner for providing legal support to our clients. We will be happy to help you invest profitably and, most importantly, safely in assets and real estate on the island of Bali. See you. Thank you.